elements in Contracts Act 1950, and one of them is acceptance that stated in Section 2B.
Yes, I do know about that. Acceptance is a final agreement to an offer. A proposal, when accepted, become a promise.
Well, on the 8th of December 1840, there was a case about acceptance between Hyde and Ranch that involved cross acceptance on estate. Do you know about that?
Oh, really? I do not know about that case. Do you mind to share with me? I really wanted to know.
Sure, Damia. Come follow me. I will show you something. One evening, Hyde and Ranch are just wandering around the park, taking his time, checking the place out, while Ranch raced along next to him, not saying much. First offer, 1,200 euro. Second offer, 1,000 euro. Hyde's offer, 950 euro.
So, this is my farm that I mentioned in the letter last time. How do you think? Does it suit your interest?
Your farm is in pretty good shape. Yeah, I think it's perfect for a long-term investment.
Exactly. That's why I asked for 1,200 euro. For land this fertile, I would say that price was fair and affordable.
1,200 euro. It's not a small amount. Can you reduce the price a little bit?
Oh, I get that. I will reduce the price by 1,000 euro. But please take all the time to consider my offer. However, I will emphasize that this is my official proposal.
At this moment, there exists a clear, definite and valid offer directed to Hyde.
1,000 euro. 1,000 euro for that land. It's a buy it for 1,000 euro. It's too steep. Maybe I can offer a bit less. 950 euro? Well, it's still reasonable, right? He might go for it. What if he gets angry? Might as well give it a shot.
What Hyde is doing here is not an acceptance, it's a counter offer. Under the law, this rejects the original 1,000 euro offer.
What letter is this on my table?
It was from Mr. Hyde.
What? 950 euro?
So, you would like to reconsider that price?
Absolutely no. I insist my intention to sell the farm at the price of 1,000 euro. Mr. Hyde, I sincerely apologize for rejecting your offer of 950 euro.
So, is this matter settled?
Yes. No agreement, no contract exists.
Now, no valid offer exists between them.
What is this? He rejected my offer. God, I messed up.
The problem is Hyde tried to accept an offer that no longer exists.
Too late.
Rex, Mr. Hyde, you cannot enter without permission.
You don't stay here. I want to see the rent. Rent? I have already agreed on the original price. Is it not enough?
Mr. Hyde, when you make an offer of 950 euro, it means you have rejected my offer, which is 1,000 euro.
But I tried to negotiate.
But the law didn't recognize that way.
I'm not satisfied. See you in court.
This is the main conflict in the case of Hyde and Ranch.
court is now in session. The case before this court is Hyde versus Ranch. Counsel for the claimant, you may proceed.
Your Honor, the claimant submits that there was a valid offer made by the defendant to sell his farm for 1,000 euros. The claimant later attempted to accept the offer. Therefore, a binding contract existed, and the defendant's refusal to proceed amounts to a breach of contract.
Your Honor, the defense respectfully submits that no contract was ever formed. When the claimant responded by offering €950, this constituted a counter-offer, not an acceptance. By law, a counter-offer terminates the original offer. As such, the original offer of €1,000 was no longer available for acceptance.
Counsel for the claimant, how do you respond to the argument that the counter-offer extinguished the original offer?
The claimant believed that the original offer remained open. The intention was merely to negotiate the price, not to reject the original offer.
Your Honor, the law is clear. A counter-offer is a rejection of the original offer, regardless of intention. Once rejected, the offer cannot later be accepted, unless renewed by the offerer.
After considering the submissions, this court finds that the claimant's offer of €950 was a counter-offer, which terminated the original offer of €1,000. Therefore, no valid acceptance occurs. No contract was formed. Judgment is entered in favor of the defendant.
This case was brought to and decided by High Court Judge Lord Longdale because Hyde unsatisfied when Ranch refused his offer and didn't let him accept the €1,000 offer. To constitute a valid agreement, there must be a simple acceptance of the terms proposed. The plaintiff, instead of accepting the alleged proposal for sale for €1,000 on the 6th of June, rejected it and made a counter-proposal. This put an end to the defendant's offer and left the proposal of the plaintiff alone under discussion. That has never been accepted, and the plaintiff could not, without the concurrence of the defendant, revive the defendant's original proposal.
Okay, now I understand the judgment of the case. So that means a counter offer operates as a rejection of the original offer. Once an offer rejected, it cannot later be accepted unless the offerer renews it.
Yes, that's right.